Question 1. A California notary public is presented with a document for an acknowledgement. The signer provides a foreign passport from a country recognized by the U.S. government, which expired 2 months ago. What is the appropriate action for the notary to take? A. Refuse the notarization because the foreign passport is expired. B. Accept the foreign passport as valid identification since it is from a recognized country. C. Accept the foreign passport only if the signer also provides a secondary form of identification, such as a credit card. D. Accept the foreign passport if it contains a serial number and a photograph. Answer: A. Refuse the notarization because the foreign passport is expired. For identification purposes, all acceptable forms of identification, including foreign passports that have been stamped by the U.S. Citizenship and Immigration Services, must be current or issued within the past 5 years. An expired foreign passport, even from a recognized country, is not valid for identifying a signer for a notarization. A notary's primary duty is to verify identity accurately. Accepting expired identification would compromise the integrity of the notarization. Remember to always check the expiration date on all identification presented to ensure it meets the state's requirements. Question 2. A signer requests a notary public to certify a copy of their driver's license for a job application. How should the notary respond to this request? A. The notary may certify a copy of the driver's license if they personally saw the original document. B. The notary may only certify a copy of a driver's license if the state allows for copy certifications by document custodian. C. The notary must refuse to certify a copy of a driver's license, as it is a vital record. D. The notary may make a certified copy if the signer signs an affidavit stating it is a true copy. Answer: C. The notary must refuse to certify a copy of a driver's license, as it is a vital record. Notaries public are generally prohibited from certifying copies of vital records, such as birth certificates, death certificates, and driver's licenses, because these documents are typically issued by government agencies and only the issuing agency can produce certified copies. Attempting to certify such a document would exceed the notary's authority and could lead to legal consequences. When a request is made for a certified copy, always verify if the document falls under the category of records that a notary is legally permitted to certify. Question 3. A notary public performs a notarization for a signer who is physically unable to sign their name. An assisting person guides the signer's hand to make their mark on the document. What specific entry is required in the notary's journal for this type of notarization? A. The notary must note that the signer made a mark and list the name of the assisting person. B. The notary must record that the signer was assisted and obtain the thumbprint of the assisting person. C. The notary must record that the signer made a mark, and the assisting person must sign the journal as a witness. D. The notary must record that the signer made a mark, and the assisting person's signature and residence address must be entered in the journal. Answer: D. The notary must record that the signer made a mark, and the assisting person's signature and residence address must be entered in the journal. When a signer makes a mark, such as an X or other symbol, instead of a signature, and an assisting person guides the signer's hand, the notary must enter specific information about the assisting person in the journal. This includes the assisting person's signature, and crucially, their residence address. This detailed entry provides a clear record of the circumstances of the notarization and enhances its legal integrity. Always ensure all required fields in the journal are fully completed for each notarization, especially when special circumstances arise. Question 4. A notary public is requested to notarize a durable power of attorney. The signer appears coherent but states they do not fully understand the implications of the document, as their adult child prepared it. What action should the notary take? A. Proceed with the notarization, as the signer appears coherent and capable of signing. B. Advise the signer to consult with an attorney before proceeding with the notarization. C. Explain the general purpose of a durable power of attorney to the signer to ensure understanding. D. refuse the notarization because the signer admits to not fully understanding the document. Answer: D. Refuse the notarization because the signer admits to not fully understanding the document. A fundamental duty of a notary public is to ensure the signer appears willing and aware of the document's contents. If a signer expresses that they do not understand the document, even if they appear coherent, the notary must refuse the notarization. A notary cannot provide legal advice or explain the document's implications, as that would constitute the unauthorized practice of law. Always ensure the signer freely and knowingly executes the document, and if there's any doubt about their understanding or willingness, decline the service. Question 5. A California notary public is asked to travel 30 miles to notarize a document for a client. The notarization involves one signature requiring an acknowledgement. What is the maximum total fee the notary may charge for this service, assuming a standard travel fee agreement? A. $15 for the acknowledgement plus a reasonable travel fee. B. 30. 15 per acknowledgement, plus 67 cents per mile for travel, round trip. C. $15 for the acknowledgement plus up to 67 cents per mile for travel, one way. D. $15 for the acknowledgement, plus a separate travel fee agreed upon in advance, which is not subject to a statutory maximum. Answer: D. $15 for the acknowledgement, plus a separate travel fee agreed upon in advance, which is not subject to a statutory maximum. In California, the maximum fee for an acknowledgement is set by statute at $15 per signature. However, a notary public may charge a separate, reasonable travel fee if it is disclosed to the signer and agreed upon in advance. Unlike the notarization fee itself, there is no statutory maximum for the travel fee, allowing the notary to negotiate a fair rate for their time and mileage. Always clearly communicate all fees, especially travel charges, before performing the notarization to avoid misunderstandings. Question 6. A notary public has notarized a document, and later it is discovered that the signer's identity was misrepresented. The signer's identity was verified using an acceptable form of identification, and the notary's journal entry is complete. What is the most likely outcome regarding the notary's liability? A. The notary is solely liable for any damages because they performed the notarization. B. The notary's bonding company is solely liable for any damages, as the bond covers such errors. C. The notary is not liable if they followed all statutory requirements for identification and journalizing. D. The notary may be liable only if gross negligence or willful misconduct is proven. Answer: C. The notary is not liable if they followed all statutory requirements for identification and journalizing. A notary public is generally not liable for damages if they have followed all statutory requirements for identification and journalizing, even if a signer's identity was later found to be misrepresented. The notary's duty is to exercise reasonable care and follow the law. They are not guarantors of the truthfulness of the document or the ultimate identity of the signer beyond proper identification verification. Meticulously adhering to all procedural requirements, such as thoroughly examining identification and completing journal entries, serves as the notary's best defense against claims of negligence. Question 7. A notary public is presented with a document where the signer's name on the document is John Doe Smith, but their identification shows John D. Smith. The notary should: A. Refuse the notarization because the names do not exactly match. B. Proceed with the notarization if the notary adds a note in the journal explaining the discrepancy. C. Proceed with the notarization if the variation is minor and clearly represents the same individual. D. Require the signer to obtain an amended ID that exactly matches the document. Answer: C. Proceed with the notarization if the variation is minor and clearly represents the same individual. Notaries are expected to use reasonable judgment when comparing names on a document and identification. Minor variations, such as the use of an initial instead of a full middle name or a nickname that is commonly associated with the legal name, are generally acceptable if it is clear the person presenting the ID is the same person named in the document. However, significant discrepancies, such as entirely different first or last names, would warrant refusing the notarization. Always err on the side of caution. If you have any doubt that the person is truly the named signer, it is best to decline the notarization. Question 8. A notary public receives a phone call from a friend requesting a notarization for their spouse, who is currently out of the country. The friend asks if the notary can notarize the spouse's signature based on the friend's personal knowledge of the spouse's signature. What should the notary do? A. Decline the request, as notarization requires the signer's personal appearance. B. Notarize the document but make a detailed note in the journal explaining the circumstances. C. Notarize the document if the friend can provide a current photo of the spouse. D. Advise the friend that personal knowledge is only acceptable if the friend is a credible witness. Answer: A. Decline the request, as notarization requires the signer's personal appearance. A fundamental requirement for almost all traditional notarial acts is the personal appearance of the signer before the notary public at the time of the notarization. This allows the notary to verify the signer's identity, observe their willingness to sign, and witness the act of signing. Notarizing a signature without the signer physically present, regardless of who requests it or how well the notary knows the signer, is a serious violation of notary law and can lead to severe penalties. Always remember, the signer must be in your physical presence. Question 9. A notary public advertises services for loan document signings. What additional statement is required by California law to be included in this advertisement? A. I am not an attorney and cannot give legal advice. B. I am not licensed to practice law in California and may not give legal advice or accept fees for legal advice. C. I am licensed to perform notarial acts as a notary public in the state of California. D. This notary public is bonded and insured for your protection. Answer: B. I am not licensed to practice law in California and may not give legal advice or accept fees for legal advice. California law mandates specific disclosures for notaries public who advertise services, particularly if those advertisements are in a foreign language or suggest a notary can perform services beyond their commission. The most stringent requirement for any advertisement that refers to a notary's services for loan documents or similar phrases is the inclusion of the statement, I am not licensed to practice law in California and may not give legal advice or accept fees for legal advice. This helps prevent the public from mistakenly believing a notary can provide legal counsel in complex financial transactions. Always ensure your advertising complies with all state-specific disclosure requirements to avoid legal issues. Question 10. A notary public is presented with an affidavit. The signer confirms the truthfulness of the statements within the document and signs it in the notary's presence. Which notarial act is appropriate for this document? A. Acknowledgement. B. Certified copy. C. Jurat. D. Attested copy. Answer: C. Jurat. A jurat is the appropriate notarial act when a signer is required to swear or affirm to the truthfulness of the contents of a document. The key elements of a jurat include the signer appearing before the notary, taking an oath or affirmation, example, do you solemnly swear that the statements in this document are true, and signing the document in the notary's presence. This distinguishes it from an acknowledgement, where the signer simply declares they signed the document willingly. If the document requires the signer to swear or affirm, always perform a jurat. Question 11. A notary public performs a notarization for a person who is blind. The signer's spouse, who is not a witness to the signing, reads the document aloud to the blind signer. What should the notary do? A. The notary may proceed with the notarization as long as the signer appears willing. B. The notary should refuse the notarization if the notary cannot personally verify the contents were read accurately. C. The notary should proceed only if an impartial third party reads the document aloud to the blind signer. D. The notary should proceed and make a note in the journal that the spouse read the document. Answer: B. The notary should refuse the notarization if the notary cannot personally verify the contents were read accurately. While a notary public can notarize for a blind individual, they must ensure the signer is aware of the document's contents. If the notary is not fluent in the language the document is read in, or if the person reading it is not an impartial third party, like a spouse who may have a vested interest, the notary cannot be certain the document was accurately conveyed. In such cases, the notary should refuse the notarization to protect the signer and uphold the integrity of the notarial act, as it would be impossible to confirm the signer's comprehension or willingness. Question 12. During a loan signing appointment, a notary signing agent, NSA, notices that the borrower's name is misspelled on one of the non-notarized loan documents. What is the appropriate action for the NSA? A. Correct the misspelling by striking through the incorrect name and writing the correct name, then initialing the change. B. Advise the borrower to make the correction, initial it, and then proceed with the signing. C. Point out the discrepancy to the borrower and advise them to contact the lender or loan officer for instructions. D. Ignore the misspelling, as it is on a non-notarized document and outside the notary's scope. Answer. C. Point out the discrepancy to the borrower and advise them to contact the lender or loan officer for instructions. A notary signing agent's role is to facilitate the signing and notarization of documents, not to correct or alter them, even if they are not being notarized. If an NSA discovers a material error, such as a misspelling of a borrower's name on any loan document, the correct procedure is to bring it to the borrower's attention and instruct them to contact the lender or loan officer for guidance. This ensures the appropriate party authorizes any changes and maintains the integrity of the loan package. Never attempt to correct documents yourself, as this can be considered the unauthorized practice of law. Question 13. A notary public is commissioned in California. When can the notary begin performing notarial acts? A. Immediately upon receiving their commission certificate from the Secretary of State. B. After filing their oath of office and bond with the county clerk in their principal place of business. C. After passing the exam and completing the background check. D. Once they receive their notary seal and journal. Answer. B. After filing their oath of office and bond with the county clerk in their principal place of business. In California, a notary public's commission does not become active until two critical steps are completed after receiving the commission certificate, taking and filing the oath of office, and filing the surety bond. Both of these must be filed with the county clerk in the county where the notary maintains their principal place of business, within 30 days of the commencement date of the commission. Failing to complete these steps within the time frame will result in the commission being void. Always remember that merely having the certificate is not enough, the oath and bond must be properly filed. Question 14. A notary public is presented with a document written entirely in a foreign language that the notary cannot read. The notarial certificate on the document is in English. What is the appropriate action for the notary? A. Refuse the notarization because the notary cannot read the document's content. B. Proceed with the notarization, as long as the notarial certificate is in English and the signer's identity is verified. C. Proceed only if the signer provides a certified translation of the document. D. Ask the signer to explain the document's purpose, and if it seems legitimate, proceed. Answer. B. Proceed with the notarization, as long as the notarial certificate is in English and the signer's identity is verified. A notary public is not required to understand the content of a document, only to identify the signer and perform the requested notarial act accurately. If the notarial certificate, the notary wording, is in English and the notary can verify the signer's identity according to state laws, the notary may proceed. The notary's role is not to validate the document's legality or content, but to certify the act of signing and identity. Always ensure the notarial certificate is correctly completed in English, as this is the part the notary is responsible for. Question 15. A notary public wants to send out email advertisements to potential clients. Which of the following is a permissible statement for a California notary public to include in their advertisement? A. We specialize in real estate closings and provide legal advice for your transactions. B. Notario Publico, we can help you with your immigration forms. C. Notary Public, I can draft contracts for your business. D. Mobile Notary Public for convenient service at your location. Answer: D. Mobile Notary Public for convenient service at your location. California notaries public are strictly limited in what they can state in advertisements, primarily to prevent confusion with legal professionals. Statements implying the ability to practice law, provide legal advice, or assist with immigration matters, unless specifically authorized as an attorney or accredited representative, are strictly prohibited. Advertising as a mobile notary public for convenient service at your location accurately describes a legitimate service offered by notaries and does not overstep legal boundaries. Always ensure your advertising clearly and truthfully reflects your authorized duties and avoids any implication of legal expertise. Question 16. A notary public is asked to notarize a confidential marriage license. What unique requirement must be met before this type of notarization can occur in California? A. Both parties must present proof of residency in California. B. The notary must be specifically appointed by the county clerk to handle confidential marriage licenses. C. Both parties must appear before the notary at the same time and show valid identification. D. The notary must record the confidential marriage license number in their journal. Answer: C. Both parties must appear before the notary at the same time and show valid identification. For a California notary public to notarize a confidential marriage license, a specific and crucial requirement is that both parties to the marriage must personally appear before the notary at the same time. This is in addition to the standard requirements of verifying their identities with acceptable identification. This simultaneous appearance ensures that the notary can confirm the identities and willingness of both individuals involved in this sensitive and private document. Always remember the simultaneous personal appearance rule for confidential marriage licenses. Question 17. A notary public is asked to prepare a document, such as a contract, for a client, and then notarize the signatures on it. What should the notary do? A. Prepare the document as requested and then notarize the signatures. B. Prepare the document only if the notary is also a licensed attorney. C. Refuse to prepare the document, but offer to notarize signatures on a document prepared by someone else. D. Charge a higher fee for both preparing the document and notarizing it. Answer: C. Refuse to prepare the document, but offer to notarize signatures on a document prepared by someone else. A notary public's role is to serve as an impartial witness to the signing of documents and to verify identities, not to draft or prepare legal documents. Engaging in the preparation of legal documents, even simple ones, constitutes the unauthorized practice of law, which is strictly prohibited for notaries unless they are also licensed attorneys. The notary's responsibility begins and ends with the Notarial Act itself. Always remember to limit your services strictly to those authorized by your notary commission, avoiding any actions that could be construed as legal advice or document preparation. Question 18. A notary public is presented with a document and requested to perform an acknowledgement. The notary notices that the document contains blank spaces that are clearly intended to be filled in later. What is the appropriate action for the notary? A. Proceed with the notarization, but make a note in the journal about the blank spaces. B. Advise the signer to fill in the blank spaces before the notarization can be completed. C. Refuse the notarization until all blank spaces are completed. D. Fill in the blank spaces according to the signer's verbal instructions. Answer: C. Refuse the notarization until all blank spaces are completed. A notary public should generally refuse to notarize a document that contains blank spaces, especially those that are clearly intended to be completed after the notarization. Notarizing incomplete documents presents a significant risk, as the blanks could be filled in fraudulently later, changing the document's intent without the signer's knowledge or consent. It is the notary's duty to ensure the document is complete at the time of notarization to protect all parties involved. Always ensure the document is complete and ready for execution before performing any notarial act. Question 19. A notary public's commission expires on June 30th, 2025. What is the earliest date the notary can apply for reappointment to ensure continuity of their commission? A. June 1st, 2025. B. April 1st, 2025. C. March 31st, 2025. D. January 1st, 2025. Answer: C. March 31st, 2025. In California, a notary public can apply for reappointment up to 90 days before their current commission expires. If a commission expires on June 30th, 2025, counting back 90 days would mean the notary could begin the reappointment process, including submitting their application and taking the exam, as early as March 31st, 2025. Applying within this window helps ensure a smooth transition and avoids any lapse in commission, which would prevent the notary from performing official duties. Plan ahead to renew your commission well within the permissible timeframe. Question 20. A notary public is performing a loan signing as a notary signing agent, NSA. The borrower asks the NSA to explain the interest rate and annual percentage rate, APR, listed on the promissory note and closing disclosure. What is the NSA's appropriate response? A. Explain the difference between the interest rate and APR as detailed in the documents. B. Advise the borrower to contact the lender or a financial advisor for an explanation. C. Provide a general overview of interest rates and APR without giving specific advice. D. Explain only the interest rate, as the APR is a more complex calculation. Answer: B. Advise the borrower to contact the lender or a financial advisor for an explanation. As a notary signing agent, one's role is to facilitate the signing of loan documents, ensuring all required signatures and notarizations are properly executed. An NSA is strictly prohibited from providing legal or financial advice, which includes explaining specific terms or implications of loan documents like interest rates or APR. Doing so would constitute the unauthorized practice of law or financial advising. If a borrower has questions about the loan terms, the NSA should direct them to contact the lender, loan officer, or a qualified financial professional. Question 21. A notary public's bond is designed to protect: A. The notary public from liability for professional errors. B. The state from losses due to the notary's misconduct. C. Members of the public who suffer damages caused by the notary's misconduct or negligence. D. The notary's employer from financial losses due to the notary's actions. Answer: C. Members of the public who suffer damages caused by the notary's misconduct or negligence. A notary public's surety bond is a financial guarantee that protects members of the public who may suffer financial harm due to the notary's official misconduct or negligence. It is not insurance for the notary, nor does it protect the state or the notary's employer. If a member of the public suffers damages directly caused by a notary's failure to properly perform their duties, they may file a claim against the notary's bond. The bond serves as a layer of consumer protection, emphasizing the public trust placed in the notary. Question 22. A notary public performs a jurat for a signer. What specific entry is required in the notary's journal for this notarial act, in addition to the standard entries? A. The type of oath or affirmation administered, example, sworn, or affirmed. B. The length of time the signer has been known to the notary. C. The fee charged for the notarial act, specifically for jurats. D. The date the document was prepared. Answer: A. The type of oath or affirmation administered, example, sworn, or affirmed. When performing a jurat, the notary must administer an oath or affirmation to the signer. To maintain a complete and accurate journal record, the notary is required to record in the journal whether an oath or affirmation was administered. This specific detail differentiates a jurat from other notarial acts like an acknowledgement and confirms that the core requirement of the jurat was fulfilled. Always ensure your journal entries reflect all the specific requirements for each type of notarial act performed. Question 23. A notary public is presented with a document for an acknowledgement. The signer insists on signing the document outside of the notary's direct line of sight, claiming it's a private matter. What is the notary's appropriate action? A. Allow the signer to sign privately, but ensure they confirm it's their signature afterward. B. Refuse the notarization, as the signing must occur in the notary's presence or be acknowledged as having been previously signed. C. Proceed with the notarization, but make a note in the journal about the signer's request. D. Offer to perform a jurat instead, as it requires the signer to sign in the notary's presence. Answer. B. Refuse the notarization, as the signing must occur in the notary's presence or be acknowledged as having been previously signed. For an acknowledgement, the signer must either sign the document in the notary's presence or, if already signed, acknowledge to the notary that the signature is theirs and was willingly affixed. A notary must witness the signing or the acknowledgement of the signature by the signer directly. If the signer insists on signing outside the notary's sight and does not then acknowledge the signature to the notary, the notarial act cannot be properly completed. Always ensure that the conditions for the chosen notarial act, including presence and acknowledgement, are fully met. Question 24. A notary public completes an acknowledgement certificate. The certificate includes the venue, State of California, County of blank. The notary must ensure this blank is filled in with A. The county where the document was originally prepared. B. The county where the notary's commission was filed. C. The county where the notarial act actually took place. D. The county where the signer resides. Answer. C. The county where the notarial act actually took place. The venue on a notarial certificate, typically formatted as State of, State, County of, County, indicates the specific geographical location where the notarial act occurred. It identifies the jurisdiction where the notary is performing their official duties for that particular transaction. The blank for the county must always be filled in with the county where the signer personally appeared before the notary and the notarization was executed, regardless of where the document was drafted or where the notary's commission is filed. Accurately completing the venue is a crucial element for a valid notarial certificate. Question 25. A notary signing agent, NSA, is preparing for a loan signing. What is the primary purpose of the notice of right to cancel, right of rescission, document in a refinance transaction? A. To inform the borrower of their right to review the loan documents before closing. B. To allow the borrower 3 business days to cancel the loan agreement after signing. C. To notify the borrower of their right to dispute any errors in the loan documents. D. To confirm the borrower's agreement to the loan terms and conditions. Answer. B. To allow the borrower 3 business days to cancel the loan agreement after signing. The notice of right to cancel, also known as the right of rescission, is a critical consumer protection disclosure provided in certain refinance transactions involving a primary residence. It grants the borrower a 3 business day cooling-off period after signing the loan documents, or receiving certain disclosures, whichever is later, during which they can cancel the loan without penalty. This right is intended to protect consumers from rushing into a significant financial commitment. As an NSA, it's vital to ensure this document is properly presented and understood, even though you cannot explain its legal implications.